Good morning, and we are live. So, hello everyone, and welcome to another episode of Voices in Motions, our live series here at Moms in Motion. So, this is where we spotlight individuals and organizations who are really making a difference in the lives of um, individuals with disabilities and their families. So today we are joined by Nick Thompson, and he's an accomplished attorney with extensive experience in estate planning, guardianship, and conservatorship in family matters. And before shifting his practice towards aging, disabilities, and family centered work, Nick spent years at two large international law firms, and he is currently serving as the adjunct professor leading the University of Richmond School of Law Aging and Disability Practice. So we are practical. We are so excited to have him join us today to share his expertise and help us better understand key topics such as wills, trust, estate planning, and administration, guardianship, and conservatorship, and more. So thank you for joining us today, and we can jump right in.
Awesome. Thank you. I appreciate you having me. These topics all could have their own multi-hour series, so we're going to try to pack a lot of information into one short 1 hour session. But to the extent that anybody has questions, please feel free to put them in the chat, interrupt me. I'm happy to answer those. My contact information is also on the bottom of the first slide. It's my email and office number. Feel free to reach out. Be happy to connect with you. As the slide indicates, I'm an attorney licensed here in Virginia. I tell people I practice from tip to tip to tip. So Fairfax down to Virginia Beach, all the way out to Bristol. So pretty much anywhere in Virginia. And my practice focuses on estate planning and special needs planning, particularly in guardianship and conservatorship context. As many might know, I used to direct the William & Mary Elder and Disability Law Clinic. Did that for about 4.5 years from September of 2020 to December of 24. And I serve as the guardianship triage champion for the Central Virginia Legal Aid Society. So essentially, when attorneys in Central Virginia take pro bono guardianship matters from Central Virginia Legal Aid, they're allowed to use me as a resource and reach out, and I kind of walk them through the process, as it's not their main practice, but they're doing it as part of their pro bono practice. So let's dive right on in. So we'll be talking about estate planning and decision-making today. And when I think of estate planning and decision-making, these are the main topics that come to mind. We'll dive into each of them, but wills, special needs trust, advanced medical directives, power of attorney, and guardianship and conservatorship. All right, so we'll dive right in. What's a will? Why does one have a will? What does a will do? A will lets an individual, known as a testator, name their beneficiaries, meaning who they leave their property to. And this is critically important for parents and family members of special needs individuals because when someone makes their will, when a testator makes their will, they can name a special needs trust as a beneficiary instead of a disabled child or sibling. And that's critically important because if an individual passes away without a will, Virginia law has a set of presumptions that generally favor the spouse and then any children that that person might have. And so without a will, an individual with a disabled child could put their child into a great predicament and at risk of losing their benefits if they don't do their planning in advance. A will also lets an individual name an executor, name the person who's going to be responsible for administering their estate. So that could be a family member or a trusted individual, could be an organization, but it lets that individual name who's going to be responsible for making sure that their wishes are carried out. Wills also allow individuals to give specific items, specific articles to specific people. Right, so this might be, mom has a special set of earrings that she wants to leave to her daughter, right? Or maybe dad has a special autographed baseball that he wants to leave to his son. Theoretically, it helps to prevent family disputes when someone dies. But then again, if there weren't disputes, there wouldn't be will contest and attorneys who deal with this stuff. So that's a hopeful theory. And it also, in the case that an individual has minor children, allows that individual to nominate who's going to be the guardian of their minor children. All right, I mentioned potentially not doing your will and someone passing away without one. This is called intestacy, right? And so intestacy is a default set of rules that Virginia, and this is state by state, but in our state, Virginia, it has, we've attempted to approximate what they think a typical person would do if she wrote a will or if he wrote a will. And so, like I mentioned earlier, generally this favors the spouse and then children. And so it applies when someone dies without a will, or when they have a will but doesn't necessarily cover all of their property. That's known as partial intestacy. And as I mentioned, generally favors the family of the decedent, the person who passed away. Again, critically important for especially parents of special needs children to make sure that they've done their planning so that they don't inevitably leave something directly to their child that would put their public benefits at risk. All right. Generally, we don't wind ourselves up in partial intestacy because we leave the remainder of property that we're not specifically giving away in wills, right? The residue is what it's called, to a trust or to a special needs trust. And this helps to pick up anything that might have fallen through the cracks. It is an entity that can hold the resources and the assets and utilize them for the benefit of the beneficiary. So specifically, a special needs trust, sometimes called a supplemental needs trust, it's a legal arrangement whereby an individual ensures that their assets and the income potentially generated from those assets are used to support an individual with a disability without disqualifying them from public benefits. Okay, and so I mentioned what happens if somebody passes away without a will, right? Potentially their children could inherit assets, which could disqualify them from their SSI, from their Medicaid, and that can be problematic. However, if the individual sets up a special needs trust, again, I'm going to use parent as the example. If a parent sets up a special needs trust for their child, leaves everything or whatever in their will to the special needs trust, the assets will go into the trust at the death of the individual, and they'll be there to support, to supplement the needs of the individual under disability without disqualifying them from their public benefits. This is a question I get a lot. People say, well, can I just draft my own? As an attorney, I would say, please don't. Generally, the special needs trusts have to comply with federal and state laws. And so maybe a self-seeking, self-serving request here, but hiring an attorney is of paramount, of critical importance. So make sure you, connect with other parents in your area, see, who they used, reach out to me. I'm happy to point you in the direction or help you myself if I can. All right, some definitions as we're thinking about special needs trust. So a grantor, it's just a terminology for the person who's creating the trust and generally who's contributing the assets to it. Sometimes this person is also called the settlor. They settle the trust. A trustee, this is going to be an individual or an entity that's responsible for managing the trust, for managing the property and the assets in the trust. They make investment decisions. They make distributions to the beneficiaries in accordance with the terms of the trust. I've used the term beneficiary a few times. In the special needs trust context, this is the person with the disability or special needs for whom the special needs trust is established and to whom the benefits may be provided. In one context, we'll talk about in a bit, a third-party special needs trust. We can have remainder beneficiaries. These are people who are going to receive any remaining assets in the special needs trust once we'll call them primary beneficiary passes away. Right, again, I'll use an example. Maybe mom sets up special needs trust for her disabled son, and she has two other children. She might name those other two children as the remainder beneficiaries to receive any property or assets left in the trust when the individual with the special needs passes away. I won't go into too much detail about pooled trust, but it's another common type of special needs trust that's under the management of a nonprofit organization. So, for example, the Arc of Northern Virginia has one. There's one around the Richmond area, Commonwealth Trust, CCT. So that is something that you can look into and discuss the pros and cons of that with those entities directly or with an attorney. Upon the death of the beneficiary, the individual with special needs, generally in those pooled trusts, any remaining funds can be paid back to the Commonwealth for benefits received, or become property of the nonprofit organization that's running the trust, and are pooled to then provide for the resources and additional needs of all of the beneficiaries of that pooled special needs trust. All right, some considerations when planning and when thinking about which type of special needs trust would be best suited for the individual. Well, one, what's the life expectancy, right? This is going to help, guide how much and how many resources should be put into the trust. That goes right to point number 2. How much money are they going to need to maintain their desired quality of life? Right? We can do a cost of care calculation to figure out, okay, this is how much we think they're going to need over their expected lifetime, and make sure that the plans can be laid accordingly. Also thinking how and when funds should be distributed. Now, there are legal requirements for this, but also there is a little bit of flexibility. And so the settlor needs to think about this when setting up the special needs trust, and making sure that they are explaining their desires to whoever is drafting the trust for them. Should the trustee, right, this is the individual or entity managing the trust, should they have control over the trust funds, or should there be a third party to oversee the spending of trust funds? And then finally, in our third-party trusts, which I believe are on the next slide, what should happen to any remaining funds should the beneficiary pass away and funds remain in the trust? Where should those go? All right, I've mentioned the word third party a few times. We also have first party special needs trust, and we'll walk through both. They're different in that primarily where the funds and the assets come from. In the first party special needs trust, these trusts utilize and are funded with assets that belong to the beneficiary, to the individual with special needs. Sometimes folks refer to these as self-settled trusts. They are irrevocable and are generally funded with, I mentioned, if you pass away without a will, process goes to intestacy. This happens often. The individual receives an inheritance unexpectedly and needs to have a first party special needs trust established. Can also happen with life insurance payouts, right? So life insurance, you can have a beneficiary designation on them. And if a parent hasn't set up a special needs trust, they may leave it directly to the individual, which is not advisable. But in the case that happens, first party special needs trust can be utilized to help correct that, and to make sure that person continues to maintain their eligibility status. Also, these come from personal injury settlements. Funds can be put into a first party special needs trust if the individual with special needs receives a personal injury settlement. One quick note about these: there are Medicaid payback requirements to them, in that if there are any funds remaining in the trust when the individual, the beneficiary, passes away, again, I'm going to use Virginia, but Virginia can then go and try to be paid back for all of the benefits that it provided through Medicaid for the individual. Okay. In contrast, a third-party special needs trust, this is established and funded by somebody other than the beneficiary. The example I used was mom setting it up for her son. That's because often these are established by a family member. They can be irrevocable or revocable depending on the drafting and the goals and drafting. They may be funded during the individual's life, but more generally, they're funded at death of the settlor. So oftentimes that's life insurance, right? So in the first party, we'll call it parent, named the individual as their beneficiary on life insurance. In this case, if the parent has set up the third-party special needs trust, they can name the special needs trust as the beneficiary for their life insurance, and the funds will go directly into that special needs trust. The individual will not be disqualified from their benefits, and they'll be there to supplement the needs of the individual. And with these third-party special needs trusts, there's no Medicaid payback requirement like there is with a first-party special needs trust. And so, again, the settlor, again, in my example, a parent can name who or what entity they want to receive any remaining funds in the trust at the death of the beneficiary. What can the funds?
Excuse me, Nick.
Yes.
We do have a few questions coming from James.
Okay.
And I know you just answered one of them. So one of them was, what happens if the person who the settlor passes away?
Mm-hmm.
James, were you able to get clarification for that question, or do you need him to go more into depth? And then while James is typing, another question that they ask is, what protections are in place to monitor those who control the trust? And I'm assuming that's after the settlor passes.
Certainly, yeah. So it's not a problem when the settlor passes away. I'll answer the first one, because generally the trust isn't funded during their lifetime, right? Again, in my example, if it's parent, generally parents just provide for their children's needs even as they become adults. And so when they pass away, there will be another person who is the trustee. It could be an entity, it could be another family member. So there, it's not a problem. And generally that's how they get funded in the first place, right? Again, we use my example of mom's life. She was providing for her son. She passed away. Maybe she had life insurance. Maybe she had a home that she we'll call it a transfer on death deed. That's another planning tool, not in these slides, but something to think about. And where the trust is now owning either the property, the proceeds from the life insurance, you name it. And those are in the trust and are there for the benefit of the individual. And so the trust continues on even absent the settlor passing away. Now, the trust generally is going to terminate when the individual with the disability passes away. And so that's where these two come into different endings. That with the first party, the funds were already that individual's in the first place. And so the theory is that the state should be paid back for the benefits that it gave the individual while they had funds, even though they didn't have direct access to them. In the third party, when the beneficiary passes away, the settlor has designated where any remaining funds should go, whether that's to another family member, to a charitable organization. They've designated that ahead of time. I think the second question was about protections for the trustee, or I guess for the beneficiary. Okay, so a couple things. So you can have a trust advisor or a trust protector. This can be, a third party, a nonprofit, an attorney. This can be somebody to oversee and ensure that the trustee is managing the trust appropriately. You can also have a group of them, right? Maybe you have 3 or 5, and I use odd numbers for a reason, but you could have a group of them who are there to make sure that the trustee is managing the trust appropriately. You can have mandatory accountings for them if you'd like. So that can be a way that, and say who those are provided to, right? Again, in my example of mom with son and 2 other children, she might give the authority to the other 2 children to request accountings annually from the trustee. And so the trustee can then be required to provide accountings to those individuals. They also have what's called fiduciary duties, right? So they owe an obligation of good faith and of loyalty to the beneficiary. And so their fiduciary obligations stem to that individual in this circumstance. And so to the extent they breach those duties, then you could have somebody come in and say, wow, and it gets kind of sticky, but, have a breach of fiduciary duty lawsuit, if you will, and ask for that trustee to be removed and replaced. That can get time consuming and expensive, but if it's drastic enough, it could be the right course of action.
And are there any, James also wants to know, what about the cost of lawyers? Are people able to get help for cost of lawyers?
Are funds in the special needs trust able to be used for the cost of lawyers? If so,
Um,
if
mhm.
so, the answer is generally yes. At least I set up mine that way. Um, Also, too, if he's referring to my breach of duty, if you prove breach of duty and that the trustee, violated their fiduciary obligations to the individual, you can get them to reimburse the trust for all of the funds. We'll assume they misappropriated funds, all the funds they misappropriated, and two, you can get your attorney's fees paid for by the trustee who breached his duties or her duties as she's getting removed. Was that the
Thank you.
question, James? Did I answer your question?
We're just going to wait for him to type.
All right.
He dropped a few more questions in here, but we can
Okay.
continue
All
and then
right.
once he responds.
Well, yeah, no problem. When I finish the special needs trust slides, if you just want to interject, that'd be perfectly fine. So for what benefits can the special needs trust funds pay? This is often a major question. Essentially, anything to supplement the needs of the individual. Now, it can't be used for things that their benefits are covering. If you think what their SSI is covering and what their Medicaid is covering, but for those extra needs it can cover. So if there are educational expenses, such as tutoring or special needs schools, entertainment and travel expenses, right? A common one is a trip to Disney, but you name it. If the individual needs a home modification or some sort of accessibility modifications, if they need medical and dental expenses that are not covered by their insurance, personal care services, rehab therapy services, again, that aren't covered by their existing benefits. All right, that's the end of trust. Did he have other questions that you want to chime in on?
It says, what happens to my home? I want to ensure, I guess this really isn't a question, but I want to ensure that my son who has autism lives in my home. His twin sister will be protected.
Yeah, so with respect to a home, there are a couple of things that we want to make sure we think about. So homes, as I'm sure this person knows, and as I know, have costs that come with them. It seems like every week, but at least annually, right? You think of if there's a mortgage, the mortgage has to get paid. Not if there, but insurance, the insurance has to get paid. Property taxes have to get paid. um, General upkeep, right? If something breaks in the home, right, there have to be funds to pay for that. And so, yes, we can authorize the special needs trust to hold the real estate, the real property. Typically, we would accomplish that with what's called a transfer on death deed, which would just say, I, Nick Thompson, own this home at this address. And I'm just very generalizing, when at my death, this home is to go to the blank blank special needs trust. Okay, and so that would get filed in my local circuit court here in the records room. And then when I pass away, just by operation of law, and I own the property, the special needs trust that I've set up and named there now owns the property. We don't want to just leave just the property to the trust because, as I mentioned before I went into that, there are additional costs to having a home, right? And so we need to make sure that there's life insurance or some sort of other liquid assets in the trust that can pay for the day-to-day upkeep of the home, whether there's a mortgage, property insurance, just roof replacement. All of these things take resources, and so we want to make sure that we don't just leave the trust with just a home and nothing else, and then there's no mechanism to pay for the upkeep and the needs of the home. And what happens then generally is the home gets sold, and the funds used to pay for a different home or to pay rent at another place. And so it's important to make sure that that there's something else just besides the real property in there.
Thank you. And his last question is there any are there taxes
Um,
involved with the special needs trust?
Taxes with the special needs trust. So generally, we don't fund those during lifetime, and so that's not. I thought I was going to say with the transfer on death deed, but so generally we fund those with a lifetime. With sorry, posthumous gifts, right? So wills. Or specific bequest or beneficiary designations, and so that's not there. There aren't necessarily tax implications during the life of the settlor, if that's the question.
Thank you.
Yep. All right, moving on to some other planning tools, right? And I'll contrast this later when we go to speak about guardianship and conservatorship. But generally, an advanced medical directive is a set of written directions that are given to a decision maker, to an agent, and they give them direction and guidance as to what sort of decisions and what sort of medical care an individual wants made in the event of their future incapacity. Okay, so for example, I might have an advanced medical directive that says, if I'm unable to make my own decisions, I want my wife to make my decisions. If my wife is not able to make those decisions for me at that time, I want my brother to make those decisions for me. And I would name them specifically in the document. I would name specifically what authority I give them. I could name what authority I specifically do not give them. And provide for very specific kinds of treatments and requests. So that's about the person, right? That's about their medical, their health care. And so that's kind of a corollary to guardianship. And we'll contrast that with a durable general power of attorney. So this is all about financial and estate planning decisions. And so these, like an advance directive, are a written set of directions given to an individual, to an agent, and provide guidance as to the future financial decisions and care of an individual who is then thereafter no longer able to make decisions. Again, I might say, I name my wife to be my agent, and if my wife's not available, I name my brother. Now, your agent under the advance directive and the power of attorney don't have to be the same, right? You could have a son who's a financial planner, and you're like, oh, I want them to be my power of attorney. And you could have a daughter who's a nurse, and you could say, well, she's knows a lot about the healthcare system, and I think she would make appropriate healthcare decisions for me. And so you can split those authorities up, although they are commonly the same person or persons. Just like with the advance directive, the durable general power of attorney can provide for very specific kinds of actions. It can withhold very specific kinds of authority. Generally, these are going to give a very broad authority to their agent, although not always, right? Someone might just want a specific power of attorney for somebody to be able to sell a piece of real property, right? They don't want to have to go and deal with it, so they might name an agent to go and handle those matters, and specifically those matters. That wouldn't give the agent the authority to go and do anything else on their behalf, but it would give them the authority perhaps to sell the home, to interact with the real estate agents, etc. Just an example. And we'll talk about capacity in a little bit, but generally for an advance directive and a power of attorney, one has to be able to understand the nature and the consequences of their actions, right? They have to understand what the documents are before them. They also have to want to give that authority away. You see it often when individuals age. Maybe they've taken care of themselves their whole life, and then they get dementia or Alzheimer's, and it's hard at that point to realize that your capacity is slipping, but they don't want somebody else to make decisions for them, yet they've gone past the point of capacity to be able to enter into an advance directive and power of attorney, and that's where the guardianship conservatorship context can come into play. All right, and speaking of guardianship conservatorship, we'll walk through some of the code requirements here. I'll talk about what a general timeline and the process might look like, and then we'll finish with some common misconceptions, and I'll take any questions. All right. Before we dive into these definitions to kind of set our thoughts here, it's important, and I think a backdrop of understanding is that an individual is presumed to be their own guardian when they turn 18. So when a person turns 18, they are their own guardian. Okay, when I turned 18, when Chantea turned 18, we're our own guardians. We make our own decisions. Okay, unless a court has deemed somebody unable to make their own decisions. Okay? And so that's kind of the backdrop and where the need for a guardian or conservator can come into play. So a few definitions, and this one will come up at the very end when I talk about requirements of guardians after they're appointed, but annual reports. So there's this report form that guardians have to file annually, as the name implies, with their local Department of Social Services for where the individual resides. Okay, it's a 4-page form, asks some pretty straightforward questions, where they're living, what kind of care they're receiving, is a guardianship still needed, but those should get filed annually with the Department of Social Services where the individual is residing. Conservator, so this is the corollary to the financial power of attorney or the general power of attorney. It's a person who's appointed who's going to be responsible for managing the estate and financial affairs of an incapacitated person. And guardian, again, this corollary will be to the agent under an advance directive, but this is a person who's appointed who is making decisions with respect to one's personal affairs. Think their health, their care, their safety, their support, their education, their therapeutic needs, where they live, all of those sorts of personal decisions are decisions that guardians make. All right. So I'm going to violate the key rule of slides here with both of these next two, and then I'm including too much information on the slides. That's to drive home a point that a lot of information has to be provided to the court. We can't just say this person has blank diagnosis, court appoint me as guardian. The court takes very seriously the question of, someone needing a guardian. And so they require a lot of information for the process to be completed appropriately. The main one that I draw people's attention to, and that when I'm giving a CLE on the guardianship topic, is the third bullet down. So we have to include the names and post office addresses of the respondent, the individual over whom the guardianship is sought, of their spouse, their adult children, their parents, and their adult siblings. So if a person has 12 siblings, they're all adults, we have to list them all, and we have to send them all notice once we set the hearing. This also means that for single parents, if they know the name and address of the other parent, regardless of how uninvolved they've been, we're supposed to include their name and address, and they're supposed to get a copy of the petition and the notice. So it's important that when you consult an attorney for this, that you provide all of this information, because what's going to happen during the process, and we'll talk in a slide or two about, is the court's going to appoint a guardian ad litem, and he or she is going to investigate the petition, and they're going to dig, and they're going to try to find dad or mom who is not involved. And if they do, and you could have found them, it doesn't really look good to the court. It looks like you're trying to hide something. And so it's important to be forthcoming about those items. All right, again, this is a continuation of the slide, but all of this additional information has to be provided, right? The court's going to want to know what kind of guardianship, a full guardianship or a limited guardianship is sought. They want to know about the plans for their health care and safety and where they're going to live. They're going to want to know what's the native language, right? If their native language is French, then the court's going to get a French translator during the process. And that's important so that the individual can be apprised of their rights during the process. Okay. Again, don't need to walk through all the specifics there, but basically to drive home the point that a lot of information has to be included per the guardianship code. And we also submit a medical evaluation. So the medical evaluation is supposed to evaluate conditions of the respondent. Okay. The report's supposed to address the nature and type and extent of the incapacity, including any specific functional impairments. It's supposed to provide a diagnosis or assessment of the condition. They're supposed to list the date or the dates of the examination, the evaluations and assessments upon which the report is based, and the evaluator is supposed to sign it. It's helpful if this is filled out by the person's primary healthcare provider, although not a requirement. This report can be filled out by one or more licensed physicians or psychologists, or the code says licensed professionals skilled in the assessment and and treatment of the physical or mental conditions, right? So this can be an NP. It can be, I've had licensed clinical social workers complete these forms for me. Generally, whoever knows the individual best and has thorough knowledge of their condition would be helpful to have them complete the evaluation. Parents also ask me, well, my kid sees 5 doctors. Which one do you want me to have fill out? Generally, my response is, well, 1, the one who knows them best, but also 2, the one that's going to fill out the report for you fastest and get it back to you. I've had a doctor fill it out in 30 minutes and get it back to me. I've also had a doctor take 4.5 months. And so if you are starting this process at 17 or 17 and a half, you probably don't want to have to wait 4.5 months to get the medical evaluation back so that the process can begin. All right. Once everything's been filed, so the petition, the medical evaluation, and some other supplemental documents, we're going to set a hearing date. Okay. The court's supposed to set a date within 120 days from the filing of the petition. And that hearing is going to be at the circuit court for where the individual lives. Okay, we're going to take that notice and it gets mailed out to all of those people that we listed in our petition, right? All of the siblings, parents, adult children of the individual. And the respondent is going to get personally served with a copy of the notice. They can't waive that notice, and it's important. It's jurisdictional, right? If they don't get personally served with a copy of the notice, the court is not going to appoint a guardian. It has to happen. It's a critical portion of the guardianship process. Okay. I already mentioned the third bullet. So we mail out a copy of that with the petition at least 10 days before the hearing. And the notice has to include these big, bold 14-point type warnings to the individual and advisement of their rights. The individual has, for example, the right to put on their own evidence, to contest the guardianship, to have an attorney of their choosing, to have a jury trial if they want one. So they have these rights that are critical to the process and are listed on the notice. Stop. All right. So the notice has been sent out. The hearing has been set. And at the hearing, the court's going to hear the evidence before it. It's going to rely on the medical evaluation. It's going to rely on the information that has been provided in the petition. And I mentioned earlier, but during the process, a guardian ad litem is going to get appointed. And he or she is going to come and meet with the individual and put together their own assessment as to the need for a guardian or conservator and as to the appropriateness of the person requested. And so the court's going to hear all of that. Generally, the hearings go pretty smoothly because the court's reviewed all of those documents and the filings in advance. And the attorney and the guardian ad litem have drafted, an agreed order. And usually the court, wants to just look the proposed guardians in the eyes and, see if they have any question, to advise them of what they're supposed to do as guardians, and then to enter the order. Okay. And you'll see in the second bullet, the court is supposed to advise the guardian that, and these are relatively new. And I think when I talk about common misconceptions, these weren't around. These have only been around, or these instructions, for I'd say 5 or 6 years. And so they're relatively new, and I think lead to this kind of old stigma that you're just stripping the person of all their rights and they're not going to be able to participate in their decision makings. But quite to the contrary, the respondent is supposed to be encouraged to participate in their own decision making to the extent possible, right? We know that there's a continuum of being able to make decisions, to act on their own behalf, to develop or maintain the capacity to manage their own affairs. And so they're really instructed to try to maximize the independence of the individual to the extent possible. All right. In the court's order of appointment, they're supposed to consider a few other things, right? We talked about advance directives and powers of attorney. Well, guardians don't need to be appointed for somebody who has an agent under an advance directive. That's why it's important for parents and other family members to do their planning, to have their own documents drawn up and drafted so that they don't in themselves need their own guardian or conservator. Right? It's the whole, put your own oxygen mask on before putting, the oxygen mask on for other people. Make sure that you have your affairs in order so that nobody has to go through the guardianship process for you. Right? I mean, you're already having to think about this for your children or for another loved one, but just make sure your own affairs are in order, because if you have an agent under an advance directive, generally someone's not going to need to go through the guardianship process for you. Likewise, if you have your own agent under a power of attorney, someone's not going to need to be appointed conservator over you. All right. And all guardianship orders have to include this big, bold 14-point type. You're going to see it on the next slide here. It's a lot of information, right? This big, bold, you have to do this stuff. Okay, so it's going to list in number 1 all of the duties and powers of the guardian that they have. It has to make a statement of the rights that are removed, right? Generally, that's going to be the right to own or possess a firearm. Other rights that may or may not be retained or lost are the right to drive and the right to vote. But if the individual, has the capacity to do those things, I've found that it's not too difficult to retain those rights, as long as they have the capacity to do those things. Okay, again, echoing what the court is supposed to instruct the guardian, it's in their order, and I'll read bullet 2. The guardian, to the extent possible, shall encourage the incapacitated person to participate in decisions, shall consider the expressed desires and personal values of the incapacitated person to the extent known, and shall not restrict an incapacitated person's ability to communicate with, visit, or interact with other persons with whom they have an established relationship. Okay. Bullet 3, we talked about the annual report that has to be filed with the Department of Social Services. And then finally, bullet number 4, all guardianship orders are subject to a petition for restoration of the incapacitated person to capacity or some other form of modification. 1 second. Sorry, I think my 3-year-old left his candy in here. Okay, 1 second. Retreat last night. There we go. I'm back. And my son left his candy in the office this morning. All right, perfect. Yeah. So I think I just finished up question 4, bullet 4. All guardianship orders are subject to petition for restoration. All right, let me go to the next slide. Boom. All right. So that's kind of in a nutshell from beginning to having a guardian or conservator appointed. I typically will break it into 4 categories. You'll see the initial filing phase, right? That's where the attorney's gathering all that information, drafting all those documents that get filed with the circuit court in the city or county where the individual resides. Okay. Once that gets filed, it usually takes the court a week on average, sometimes 2, to process that, to get a case number for the filing, and to appoint a guardian ad litem. Okay. Once that guardian ad litem is appointed, we can then go ahead and schedule the hearing. And different jurisdictions handle this differently. Some places like Loudoun and Fairfax do these on Friday mornings at 9 a.m. And you work out a date that works for everybody, and you can get it docketed on pretty much any 9 a.m. Friday in those jurisdictions. Other places, more so around like Central Virginia, you reach out to the judge's assistant and ask them for specific dates in order to set a date for a hearing. And then some places down in Tidewater, they have motions docket. Like Norfolk has a motions docket any morning at 9 a.m. If your motion's going to take 15 minutes or less. Chesapeake does these Wednesdays at 9 a.m. Virginia Beach has a duty docket in the afternoon. So each particular jurisdiction kind of handles scheduling differently. But in one way, shape, or another, you get the hearing date set for a date that works for the guardian ad litem, for the petitioner, for their attorney, and for the proposed guardians. And then the notice gets sent out to all those relatives. During that interim process between, setting the hearing and the hearing, the guardian ad litem goes and they visit with the respondent personally, and they serve them with a copy of their notice, and they investigate the petition, the medical evaluation, and review everything and put together a report, right, that addresses a number of factors with respect to the individual needing a guardian, and to the appropriateness and suitability of the proposed guardian. Then there's a hearing. It's supposed to occur within 120 days of filing the petition. Generally, I'd say it's closer to 4 to 8 weeks, just depending on jurisdiction. Can be shorter if needed, can be longer. As parents, you can begin this process. The filing can occur at 17 and a half. Okay, so that initial filing on the left side here, all that can get filed at 17 and a half. And that's helpful because it provides a nice buffer in order to finish up the entire process before the individual turns 18. Okay, generally I ask parents, please reach out to me by the time your kid turns 17. That way I can send you the documents that you need to fill out, that the doctor needs to fill out. You can get them back to me in plenty of time, and I can have everything queued up and ready to go and drafted so that when they turn 17 and a half, it's getting filed. And that'll start the process, and that'll make sure that everything is done in plenty of time before the child turns 18. Now, if they're already 18, it's not a problem. You can file it right away. But it's one of the challenges I hear is parents come to me and they're like, "Well, my kid turns 18 in 3 days." The process takes some time, and so make sure you're reaching out to prospective counsel anywhere between 16 and a half and 17. Making sure that you get everything you need, you can provide them everything they need, and then the process can move smoothly from there. Okay, so those are kind of the first 3 phases. And then this last phase, I call it the post-appointment requirements. So after the hearing, after the guardianship hearing, the judge signs the order. Usually they're going to give it back to the attorney, and they're going to say, take this down to the clerk's office and get copies for everybody. In most jurisdictions, we'll have provided them with these top 2 forms. It's an incapacitated adult information form, as well as a state police form. The state police form goes to the state police and informs them that the individual is not permitted to own or possess a firearm. And then the probate clerk or some other clerk in the circuit court office will qualify the individual, which means they're going to come in before the clerk and they're going to receive a bunch of paperwork from the clerk, including copies of the order. And they're going to take an oath. They're going to say, I, guardian, am going to make decisions in the best interest of my ward. They're going to sign a piece of paper, and then they're going to submit that, and they'll leave with a copy of the order and a 1-page certificate of guardian. Okay. There are the bullet 3 and bullet 4 are other requirements. So they have to complete a guardianship training that's been developed by the Department of Aging and Rehabilitative Services, DARS. And that's supposed to be completed within 120 days of the qualification. For guardians that were appointed before July 1 of this year, they have until January 1 of 2027. So they have a little bit more time, mainly because they might not know about the training, and they want to give them time to learn about it and get it taken care of. I mentioned it as the first definition and kind of in the process, but they have to also complete an annual guardian report. And usually when I email a closing email to my clients, I include a fillable version of that. That way they can save it to their computer and have it so that they can just modify it year to year as things may or may not change. The first guardian report is due within 6 months of the qualification of the guardian. It goes to the Department of Social Services where the individual resides, and it gets filed every year thereafter. Right? So if somebody were appointed today and qualified today, December 31st, theirs would be due, April, the end of April 2026, and every year thereafter. And then the last one, in the 2,500 or so guardianships that I've done in my lifetime, only once have I ever issued this notice of restriction. It was a guardianship and conservatorship, and everybody knew it was coming because an individual had been taking financial advantage of this nice old lady. And so literally a day after the conservator was appointed, I issued this notice of restriction, served it on the other woman, and she didn't see her again. But that's pretty rare to have to use that. All right, and I think this is my last slide. Just have a couple of common misconceptions, I would say. The first one I hear is, well, I'm taking away all of my insert child's rights. And usually my response is, well, what rights are we taking away that the individual is going to be exercising? If they're going to be exercising their right to vote and the capacity to vote, that right can be retained. Same with driving. If they're going to be driving, they have the capacity to do that, then they can retain that right. Generally, the three that I think of when I think of losing their rights are, one, the right to own or possess a firearm, which I don't think anybody has ever said I want them to retain that right to me. The second is the right to enter into a contract without the guardian's consent. Okay, I kind of view that as a protection, right? And I tell this to parents all the time. I say, look, you care for your child. That's why you're doing this. But unfortunately, a lot of the world will look to take advantage of them. And so without these protections in place, it's possible that someone could have them enter into a contract that they don't understand. And that can create a lot of problems. And then the last one is the right to get married, again, without the consent of the guardian. Again, I typically view this as protection in that, especially with these individuals, they're often on public benefits, and there can be some serious complexities to public benefits when an individual gets married. And that's not necessarily something that I guess could be thought of in the process. And so it'd be helpful to have the guardian there to kind of think through that and understand what that's going to mean from a benefit perspective. All right. Second bullet, I was told by my child's case manager to start the process when he turns 15 because the process can take years. It doesn't take years, plural. But again, if you reach out between 16 and a half and 17, I'd say that's plenty of time to get everything, get it filled out, get it submitted, get questions followed up on, and everything filed at 17 and a half and process completed by 18. But also kudos to the child's case manager for bringing this to the parents' attention. I can't tell you how many people, they're like, well, my neighbor told me about this, or, my friend in this group told me about this, and my kid turns 18, or he just turned 18. I've got no clue. So kudos to the case manager for bringing this to the parents' attention. The other one, guardianship will fix all of my child's behavior and mental health needs. It doesn't fix behavior or mental health, but it does give parents the guardian, I'm assuming parents, the authority to help to make decisions for the individual, whether that's for their care, their safety, their therapeutic needs. So it gives them the authority to make those decisions. Other one, my child's school and care providers will continue communicating with me even after he turns 18. Sometimes, although not always. And I don't advise any schools or any care providers, but if I did, I'd probably tell them not to, because that unless they're their guardians, that individual is their own guardian. That's what the law presumes. Others, the state will come take my child away if I don't have guardianship of him at 18. No, that's not true. I think that's a big concern. But, for example, I have parents of 40 and 50-year-old children who are like, man, I just heard about this guardianship. And they've been caring for their 40 or 50-year-old child their whole life, but they want to get the guardianship in place so that they can then name a successor to take over when they no longer are alive. All right, I'm already my adult child's guardian by virtue of being his parent. Well, no, you were your minor child's guardian by virtue of being his or her parent. But once they become 18, unless there's a guardianship order in place, he or she is their own guardian. Aren't they impossible to terminate? No. As I mentioned, that fourth bullet of what has to be included in the orders, they're all modifiable, terminable. You just don't see it that often because circumstances don't necessarily change. But if they do, I actually have a hearing next week on one where we're terminating a guardianship. The individual has, regained the capacity to make decisions for themselves. And so the court is going to terminate the guardianship and they're going to make all their own decisions. All right. I can already make medical and financial decisions for my child, even though he is an adult. No, that is not true. Again, I don't advise banks, but if I did, I would say, don't let them do this. This person's their own decision maker. Lastly, I was quoted $7,500 by an attorney for the whole process. That is a bit excessive and costly. I or someone I know will gladly find you a better quote than that, and can get it completed for a much more feasible price. I think that's it. All right.
Awesome.
Back to my first slide, so people can have, if you want my contact information, it is right there, and my phone number, and I left a few minutes for questions. Did any come up? Oh, I think you muted yourself. Okay.
Sorry. Thank you. Sherry wants to know, what are your thoughts regarding assigning an older child without special needs to be the beneficiary of a trust rather than having the child with special needs to be the beneficiary of a SNT?
Don't do it. Don't do it. Things could happen to your older child. Maybe they run a business and now they're going bankrupt, or maybe they're married and now they're getting divorced. The only way to ensure that those funds are going to certainly be there for your disabled child is to set up a special needs trust and put the funds in there. Another option that I didn't mention today, but you don't need an attorney to help you with, is an ABLE account, ABLE, ABLE account. Frankly, I think people, who should have both, if at all possible. An ABLE account can kind of operate as a savings account, if you will, and can have up to, I believe the limit's $100,000 in it without affecting the individual's benefits. And so people can contribute to that account, and it can be there for the additional needs of, the individual. So kind of go hand in hand. But as far as, and again, she's probably using my example, we'll say, mom with 3 children, one of whom has special needs, saying, I'm just going to leave everything to my other 2 children, and they're certainly going to take care of my, disabled child. I would strongly recommend against that because life happens.
Thank you. And then the last question is from James. They want to know, where can I find a blank guardian report for my wife and I?
Certainly. If you want to email me, I'll send it to you. I can send you a fillable version. Also, too, the circuit court where you qualified should have provided you one, although that's going to be a hard copy. It's not going to be blank. You might also be able to contact your local Department of Social Services, and they provide you with one. But if you shoot me an email, I'd be happy to send you one.
So, James, in addition to his email being on the screen, I also inserted it into the chat. That way you can just copy and paste.
Thanks. Any other questions?
Do we have any other questions? And Amber says, I missed the first 30 minutes. Will this be available to watch live? Yes. And afterwards, after watching it, if you have any questions for Nick, feel free to email him. His email is once again on the screen, and we dropped it in the chat as well. Any additional questions? All right. So thank you again, Nick, for taking the time to join us today. We really appreciate your knowledge and your insight. And I also want to thank everyone who joined us live today. We really appreciate you. And if you would like to share this live or watch it with a friend, feel free to watch it on our Facebook, and it'll also be posted on our YouTube. We hope this discussion today helped you feel more informed and empowered when navigating estate planning, guardianship, conservatorship, and related matters. So thank you again. I hope you guys have a great weekend and a safe Halloween.
Thanks.
Thank you. Bye.